Australia and New Zealand approached the International Court of Justice in 1973 regarding France's ongoing atmospheric nuclear tests in the South Pacific Ocean. New Zealand filed an application to the ICJ to seize the nuclear tests. The plaintiffs argued that the nuclear tests led to fallout of nuclear waste in the ocean, thus constituting a breach of their rights under international law. France responded by requesting that the case be removed from the court list. Throughout the entirety of its proceedings, France maintained the view that ICJ was manifestly not competent and did not respect its jurisdiction. The defendant did not submit a counter-memorial to New Zealand's initial application, and therefore did not participate in any of the proceedings in 1973 or 1974, and did not appoint an agent nor file any pleadings in regards to the case. The ICJ then declared this to be under international jurisdiction and rejected the notion to dismiss the case. However, once the ICJ acknowledged its rightful jurisdiction, France declared all tests to be completed. The French president gave a series of speeches directed at Australia, claiming to have finished all nuclear testing in the South Pacific. Justices of the court brought forward the sole relevant question whether the language employed in any given declaration does reveal a clear intention. It is apparent in international law under the Vienna Convention on the Law of Treaties that obligations cannot be imposed upon a state without the consent of the other party. Notwithstanding Article 34 of the Vienna Convention, there are circumstances in which unilateral acts are recognized under international law.
The ICJ concluded that the French president and other official statements were sufficient for unilateral obligation. The intention of a single state to commit an act that seizes an isolated action constitutes a unilateral obligation because the act carried out no longer affects any parties subject to the acts. Upon statements of intention, an actor is therefore bound according to terms following a course of conduct consistent to the oral obligation. France's statements were clearly made in good faith, and all interested states are entitled to require that the obligation be respected. It was determined, even though statements were made only to Australia, that statements made by France were ergo omnes, meaning that there was no need to make the same statements to each country, as these statements sufficiently incorporated all parties involved in the jurisdiction. Furthermore, it is not determinate whether statements are written or oral in the case of a unilateral act, as both are considered binding in the international sphere of law. The issue at hand was decided in a 9-6 vote that there was no longer a conflict to be adjudicated, therefore dismissing the case. This case proves vital for the future of unilateral acts in a world of rapid development in the areas of politics, economics, and technology. There is a need for a growing presence from international bodies to interpret and resolve unilateral obligatory disputes. There is currently an area of ambiguity on what constitutes a unilateral act, therefore disputes are unable to be resolved by individual actors. This case has helped formulate proper guidelines and sets precedent for the establishment of a unilateral act.